Welcome to this episode of Law Girl. I'm Jasmine Daya, coming to you from my personal injury law firm, JD & Co., located in the heart of Midtown Toronto. Joining me is Stephen Pauwels. Stephen is the co-founder of BridgePoint Financial. He holds a Master of Business Administration from the University of Toronto Rotman School of Management. Stephen has played a leading role in the Canadian litigation finance market since 2002, developing specialized products that have assisted plaintiffs, law firms, and support service providers. There's a lot more that Stephen has done. That is his condensed bio. Stephen, let's get started. My intention of inviting you over was to discuss BridgePoint in an attempt to demystify it and explain some of the services that your company provides with respect to client funding and law firm funding. But before I delve into that topic, tell us about yourself. How did you get into such a specialized area?
Thank you, Jasmine, and thank you for having me. It's a pleasure to be here. How did I get into the area of litigation finance? That is a subject that could take our entire time slot, quite possibly. But in short, I was working in investment banking for about a decade here in Toronto and in the UK. Was not very happy with aspects of the banking world. I have a little more of an entrepreneurial bent that was certainly not being addressed as a cog in that particular wheel, but it was a great background. I'm certainly quite well versed in the areas of finance and funding businesses of different types and funding challenges that those businesses and individuals can face. But it was my then girlfriend, now wife, actually, who deserves the credit for the inception of the business concept. She's a case manager. She worked independently as a consultant for quite a number of personal injury firms in and around the Toronto area, and she saw firsthand through her dealings with these accident victims the funding challenges that they faced on a daily basis. I mean, obviously the lawyers contend with the back and forth with the defendants and the insurers and the mediations and what have you, but these clients grapple with serious upheaval in their lives, and she as a case manager would be the one that they would often call at all hours to explain the stress of eviction notices and financing challenges they were facing, and it was very frustrating for her to see how much of the time of the sessions, for example, with social workers and occupational therapists and other counselors and psychologists to help these people try and put their lives back together, was occupied dealing with these financial issues. You'd see it on a regular basis with your clients, and so she would ask me repeatedly why my bank or a bank couldn't help these clients of hers, these people going through the personal injury litigation process who had very serious cases and were due to receive very significant settlements from these cases, why someone couldn't provide interim financial support. And she never liked my explanation that banks just don't get that.
It's true. Banks don't get what we do. They really don't. And I can say that firsthand because I'm always battling with my bank about the same situation.
Well, just like they don't understand your business and contingency fee-based legal practices as a business, they certainly can't expose themselves to what they consider to be, and essentially what is litigation risk. And these clients aren't able to make the monthly servicing that banks, require. There's no ability to predict accurately when the case is going to resolve and timing. So, this entire universe of people who most need support, financial support amongst other types of support, really fell through the cracks under the current banking world, and I saw an opportunity to address that market, and I eventually did that, and about 15 years ago started providing a dedicated service to help plaintiffs, and that evolved into working with the law firms too.
How did you come up with the name BridgePoint?
Well, great question. What we provide is bridge funding. We're here to help these people get to their ultimate resolution, the settlements with their the resolution of their litigation. So we're a bridge funding arm, and so we just looked at some name that reflected that. I think we looked at Northbridge at one point, and that was taken. So yeah, we settled on BridgePoint.
You are based out of Toronto, but you do serve other areas. We
do. We're essentially across Canada. We don't operate in Quebec because of the lack of a tort system there. And we're a little more limited in some of the provinces of Manitoba and Saskatchewan because of some of the nuances of their motor vehicle accident insurance regimes. But otherwise, we are coast to coast, assisting law firms and plaintiffs in those markets, and have team members based both on Eastern Canada and in the West Coast as well.
It is my understanding from what you've already told us, as well as what I know about your business, that your company attempts to provide financial assistance to various people in the personal injury world. Is that correct?
That is correct.
Okay. So that's good. I got one thing down.
We offer services beyond personal injury litigation. So the specialty is litigation, class action, commercial employment. There are other markets, but personal injury is the original and largest component of our business. Yes.
So how are you doing this? I understand there's various different categories, can we call them?
Sure.
And so can you tell us what they are? And then we can talk briefly about each of them.
Absolutely. So I think the key distinction, because there are different layers within our service offering, but we provide funding in the form of loans, credit facilities, what have you, just like a bank would, to a very specialized sector of the market. And as mentioned, that is litigation. So the clients of ours are generally fall into two categories. They are the actual plaintiffs pursuing these legal cases who need the bridge funding for various needs, and so that is our plaintiff financing space. And then there is funding that is geared towards the actual lawyers who represent these individuals. So we fund, for example, obviously the personal injury firms need access to funds to build their cases, to spend on the various experts and other disbursements to move these cases forward. And as we discussed, the firms themselves fall through the cracks of our existing banking, lending methodologies and traditional lending philosophies. So we've stepped in to address the needs of both of those markets.
So when we're talking about plaintiffs, just for our listeners out there, we're talking about people who have, in the personal injury world, we'll keep it to personal injury because that's what I do. But we're talking about an individual who has sustained an injury due to the negligence of someone else or something else, and we are suing. And that individual that has commenced the lawsuit is the plaintiff. And so when the plaintiff comes to me, and at times an injured party has no ability to work due to injury, for example, and they don't have any source of funds, would they be able to come to you?
Absolutely, they would. If they're represented by a lawyer who has initiated that claim for the injuries that they've sustained, then we are able to look at their case and determine what assistance we can offer them to offer that interim support.
I note that you call them pre-settlement financing. When I say them, the category.
The services, sure.
But is that what we commonly refer to as litigation loans?
Yeah.
I know you don't like it.
No, it's not that I don't like it. You know what? There is a broad array of terminology in the sector. I mean, settlement loans, litigation loans, lawsuit loans, personal injury loans, legal advances. There's a full spectrum there. So I think, as opposed to avoiding the term litigation loans, which you're quite right, has some
negative connotations,
a stigma
maybe,
with respect to the legal community. As in many cases it deserves, and I'm happy to talk about that. We kind of refer to the catch-all as pre-settlement financing more in our discussions with the law firms, but make no mistake, on our website and online, we refer to settlement loans and litigation loans.
And as much as a lot of people feel uncomfortable, and we'll talk about why in a sec, but at times it's necessary. When my clients have nowhere else to go and they need to eat, they need to pay bills, they need to support their children, sometimes these loans become very necessary.
You're absolutely right. And going back to the inception of the business, my wife, as a case manager, was not out there looking for funding for her clients so that they could take a cruise or buy a snowmobile or a brand new vehicle. It was literally intended to keep a roof over their heads and lights on. So these loans are not intended for discretionary needs. It's to help your clients and those clients in need. And that's, by the way, certainly not every candidate, every client of yours is in need of these loans. It's a small subset, but it's an important subset. And these are individuals who are very vulnerable to lowball settlement offers and other tactics that force them into capitulating to the opportunistic offers that defendants can make. Because let's face it, the people opposing them, the defendants that you're pursuing to get these settlements out of, they have all the time and money in the world. They're not facing any sort of financing restriction. They can drag these cases on. Your clients are the ones that are on income replacement benefits, if they're lucky, which inevitably get cut off or inevitably are less than what they were earning before their accident. And more than half of the population has less than a month's worth of savings if they're cut off from their regular source of income.
And as we know, litigation takes years. And it's not getting shorter. The sad reality is that there are backlogs in the court systems. It takes years for these cases to wind their way through the system. And how many of your clients can legitimately withstand that through whatever benefits they might be getting? It's an access to justice issue. And we have a system that does work with the presumption that both sides have reasonably equal resources to sustain themselves financially, but there's a huge subset of the population that really can't even afford the 2 weeks or whatever period of time it takes for income replacement benefits to kick in. And if those are less than what they were earning, how are they going to make their mortgage payments? How quickly are they going to exhaust their savings? So those are the scenarios that require our assistance, and we go out of our way to obviously look at what the client's needs are and set up a structure that best serves that need. But we're very, very sensitive to the very legitimate concerns that lawyers do have, because just like any form of borrowing, it can be very effective and indispensable when it's used appropriately and responsibly, but it can be very harmful if it's used irresponsibly. And that's exactly what you and I have sort of touched upon. The whole uncomfortable situation with this term litigation loan comes with the issue that arises because of the interest rate and how people are going to use the funds and how it's going to increase difficulty in resolution at some point in the future. And I think that's what makes lawyers a little uncomfortable. There's also some comments made by judges and decisions about the rates that are charged. Do you want to weigh in on that?
Absolutely. And those are all very legitimate concerns, criticisms, and the industry, and I can say the litigation finance space is an actual industry now. I mean, 10 years ago, even 5 years ago, litigation finance as a market didn't even exist. People didn't know what that was. It's quite astounding to me that there are now dozens of companies that claim to specialize in this space. But if I were a lawyer, which I'm not, knowing what I know, I would not be happy to see a client have to borrow against their future settlement. I would be well aware of the timing risks, and I myself, I'm a debt-averse guy. I don't like borrowing. I don't think people should borrow if they can avoid it. If there are less expensive means out there for someone to get by, then absolutely they should take advantage of that before ever considering borrowing. So I think there is a whole process and responsible approach that needs to be taken both by the lawyer, but I also think it's the responsibility of the lender to ensure that the amounts being offered are appropriate for what the individual's needs are, proportionate to the underlying claim, both the prospective value of the claim and the timing of the claim. Someone who needs just peace of mind to know they can pay the rent for the next year until their trial date might be set down shouldn't be offered $10,000 in one fell swoop. They maybe need $500 a month, transferred to their account the day before their rent is due. That emulates the income replacement benefits that might have been cut off. There's an approach that has to be taken to ensure that this funding, these loans, don't end up taking a big chunk of the ultimate settlement. That's the big concern, and we've seen it happen. We definitely take steps to try and address that. On the rate front, the interest rates, our rates are credit card rates. We're 19 to 21% per year with semi-annual compounding. Your clients, many of them won't know, as many lawyers don't know, what compounding even means. But there are aspects of these loans out there that they should educate themselves on. Guess what? You're not going to find rates that are going to be much below that. We've seen players come into the space and aggressively promote even 15% interest. They don't last. There's a reason the banks really don't weigh into this space and never will. There are risks in this market. Everything is predicated on the successful outcome of these cases, and not every case is successful. Things can happen that derail these cases. There's no recourse. These people, if they had... So
if they default, basically, you're out.
Well, there's nothing... we don't even ask about income verification or assets that they might have. The last thing we would want to do, obviously, is act on someone's security if their case is unsuccessful. We're focused entirely on the merits of their case and presuming that the only way the loan is going to be paid is out as a result of the successful outcome of that case. So if these people had other resources that they could leverage or use, they would. The reality is they come to the litigation funding market really as a last resort, as they should. From the plaintiff's context, we've talked about pre-settlement financing. I understand that your company also offers treatment loans. Correct, we do. So really, treatment loans, treatment financing, these are really just like the plaintiff loans. They're loans offered to the clients, to the accident victims. The law firm is not a borrower, the plaintiff is. But the distinction is that the funds, instead of going to keeping the roof over the client's head, the funds are earmarked to pay for the various med, rehab, attendant care, other treatment needs that for whatever reason are unavailable to be covered through benefits from the insurer. I think that in recent years, given the changes to the accident benefits, yes, immense changes that have reduced the amounts that people can get for treatment, as well as the minor injury guideline, which most people are sort of lumped into, which caps individuals at $3,500, despite the policy having a lot more. Astounding. Yeah, it's unfortunate, but right now it is what it is. I think that product, the treatment loans, could be very helpful to individuals. But where would the repayment come from then? Would it come from the tort action, so the lawsuit against, in a car accident claim, the at-fault driver? Typically, yes. So, or obviously, if the accident benefit first-party insurer has simply determined that that treatment plan that you're seeking to get them to pay for is, in their determination, unreasonable or too expensive. There's a whole gauntlet of reasons they can deny or decline to approve a treatment plan, whereas from much experience, you have clients with very legitimate needs. We see it all the time. We've been asked to fund home modifications, prosthetic limbs even, and there's every excuse in the world why an insurer can fight paying for those benefits. It's too expensive. We don't think it needs that. Your client in the wheelchair doesn't need a full access ramp. There's a little thing we can get at Home Depot that costs a fraction. And really, it's to their advantage to even stall approving these expenses, where your client obviously has a duty to mitigate, to get back on their feet, literally in some cases. So there's a gap there, even where there are open accident benefits cases. But for the most part, you're right, they've exhausted their first party benefits, or those aren't available, and there's just a tort case. We can step in that situation, understand what the need is, look to the case. Our rule of thumb is, for any loan to the plaintiff, whether it's for treatment or for personally, we don't like to lend over 10 or 15% of what we think that case is worth, even a little less if it's earlier on, where it might go a bit longer.